Hello, everyone. Welcome to Children of Darkness and Light. I'm Lori Hellis. I'm your host. I thought I might just introduce myself since we may have some new followers here. So, welcome if you're new to the program. I'm a retired criminal attorney, did both prosecution and defense, and I'm an author, and I'm writing a book about the Vallow Daybell case. I have moved to Boise, Idaho to be closer to the case, which is going to start in April. And in the meantime, we talk all things true crime on True Crime Wednesday. So you can call me the Good Lori, and let's jump into it. We try really hard to keep things to start on time and to end on time because I value your time, the time you spend with us. Just a couple of little housekeeping things while people are getting caught up. Just want to remind everyone that all of your Super Chat and PayPal donations go directly to our moderators. And I want to thank you so much for everyone who donates. Those of us who are blessed and have a little bit extra to share, it's deeply appreciated by our moderators. So thank you all for that. We have some really interesting things to talk about tonight. We are going to talk quite a bit about the Alec Murdaugh case in South Carolina. And then we have a few things to talk about with Bryan Kohberger, who is the person who has been arrested in the University of Idaho college murders. So we have a couple things to talk about there, as well as quite a bit to talk about on the Murdaugh case. For those of you who aren't familiar with the Murdaugh case, Alec Murdaugh is a very well-to-do, well-connected former lawyer. Now he's been disbarred in the South Carolina Low Country. And for anybody who is just getting up to speed with the case, there are a couple places that you might want to check out. One is Gigi at Pretty Lies and Alibis, who is covering the case in person down there for Law and Crime. And also Mandy Matney, who does the Murdaugh Murders podcast. Mandy's been on the case since it began and has been covering it as a journalist down there for almost 4 years now, I think. So either one of those would be a great resource to get up to date on the case. Alec Murdaugh is accused of murdering his wife and son, and his trial started on Monday, and they finished jury selection today, which is record speed, and have sworn in a 12-person jury with 6 alternates. And we had opening statements today. Really interesting. The Assistant Attorney General, Creighton Waters, is a very experienced prosecutor. And then, of course, Dick Harpootlian, who is a state senator, is a very experienced criminal defense attorney. So it's an interesting case to see 2 really accomplished and experienced attorneys go up against one another. The judge is really modest, measured kind of a judge. And I think he's going to do a great job of managing. He's also a very experienced judge, going to do a great job of managing the courtroom and all of the stuff that's going to come in. So it's going to be a really interesting case. There were a couple of things that happened pre-trial, which y'all might find interesting. Y'all, I'm starting to sound like Gigi. Because there were a couple of motions that were heard pre-trial. One of those had to do with ballistics. And for those of you who are interested, we did a show on junk science, and this sort of goes back to that idea of junk science. So I am going to put out a newsletter about pattern science, which is essentially what it has been called into question, probably tomorrow, and look at that more in depth. But just sort of a little refresher for our last discussion about forensic science. In 2009, the National Academy of Science published a report studying some of these methods of scientific forensic analysis. And some of it had to do with whether or not these were actually reliable scientific methods rather than methods that have been accepted by the law and through legal experts. They were legally accepted ways of proving certain types of evidence, but were they really supported by scientific evidence and statistical scientific study? So that was very interesting. The study is lengthy, and I will link that both in our information from tonight's show and in my newsletter tomorrow. But the outcome was that many of these methods that we as lawyers have come to believe are reliable may not be as reliable as we have been convinced they are. And so a lot of study has gone into, in the last 10 years since this National Academy of Science study came out, into whether or not we have placed too much reliability on those sorts of pseudoscience, I guess you'd say. So the question today in the Murdaugh case had to do, or yesterday actually, the ballistics expert testified, had to do with the reliability of ballistics evidence. So in the Murdaugh case, there were 3 of these AR style guns that were purchased. Originally, Alec Murdaugh purchased one for each of his sons. He had 2 sons, Buster, who is Alexander Murdaugh, the 3rd or 4th. He's the older son. And then their younger son, Paul. Paul was the one who was murdered. And so Alec bought each of his sons one of those guns. This was a family that were very into guns. They owned a hunting property. They hunted all the time. They were deeply into target practice. There was a target range right nearby their hunting property. And they were people who had a lot of guns. They actually, in that property where Maggie and Paul were murdered, had a gun room. So there were a lot of guns on the property. So he bought these guns for his sons. Then Paul, who tended to be somewhat irresponsible, lost sight of this gun. No one really knows whether he left it somewhere or it was stolen, but his gun disappeared. And Alec then replaced it. The replacement gun is now the gun that's missing and is presumed to have been the murder weapon for Maggie. There were 2 different guns used. Paul was murdered with a shotgun. Maggie was murdered with this AR-style rifle. The shell casings that were found at the scene, because this is a kind of rifle that ejects the spent shell, the shell casings that were found at the scene matched the shell casings that had been fired at other places when those ARs had been fired at other places on the property and at the nearby firing range. They also could show that those shells had been worked through the mechanism of at least one of those AR guns. The missing gun is presumed to be the one that committed the murder, was used as a murder weapon. So there was a great deal of conversation pre-trial because they were asking for a motion in limine. We're going to talk about motions in limine in a minute. But in that motion in limine, they were asking to keep out any of that ballistic information, claiming because of all of this work that's been done in the last 10 years having to do with the reliability of pattern evidence, they were asking that evidence stay out. Now, the judge allowed the ballistics evidence to come in because what we have seen is that if that kind of scientific evidence, or even what we might consider pseudo-scientific evidence at this point, if that evidence comes in, it's the responsibility of the appellate court to determine whether or not there is a challenge that specific kind of scientific evidence should be challenged. So the judge allowed that information to come in. So what is concerning is that from the standpoint of this National Academy of Sciences report, is that this sort of pattern evidence relies on human subjective interpretation. It is not as simple as it either is or isn't this person's DNA, or it either is or isn't this particular kind of paint because we can do a chemical analysis on it. It really relies on the human eye comparing minute marks on cartridges or on bullets to determine whether or not this bullet was fired from this gun. And it relies on a great deal of human interpretation. The same is true for fingerprints and tire marks and shoe print marks and a variety of other what are sort of under the big umbrella of pattern evidence, where a human has to interpret a pattern. Hair is the same. It has the same issues because it requires a human to compare this hair and that hair and say, yes, it came from the same person based on matching up the patterns. So we're going to, as time goes on in true crime, we're going to see more and more challenges to that sort of pattern evidence, whether it's the bullets, the magic bullet, the bullets in the Delphi case, or whether it's the bullets in the Murdaugh case, whether it is shoe print evidence, which may come in the University of Idaho case and Kohberger, blood spatter evidence. All of those things require a human making a subjective comparison. And as the study, the National Academy of Forensic Science study points out, if you look statistically and compare what someone said versus what was actually interpreted, the statistics do not bear out the reliability of those methods. So hopefully we'll see more of that as time goes on. But as true crime watchers, you should be aware and expect that as you're watching these cases, more and more challenges are going to come up to the scientific basis of this kind of information. So, motions in limine. what happens in a trial is before the trial begins, the defense and the prosecution may say to the judge, Judge, we know that this particular kind of evidence was collected at the scene, and we don't believe that that evidence should come in, and here's the reason why. And we want the court to, in advance of the trial, make a ruling on this so that we don't risk that it's going to come up during trial and cause prejudice. So oftentimes, one side or the other will say we want to file a motion in limine limiting the amount of evidence or the type of evidence that can come in, because we don't believe that it is accurate, or we don't believe that it is probative. But if we bring it up in trial, it could be prejudicial to the defendant. So that's what a motion in limine is. It is interesting that if you know anything about the Murdaugh case, in the Murdaugh case, the way that this all began was that Alec Murdaugh's son, Paul, was in a very serious boat accident because he was heavily intoxicated. He ran Dad's boat into a bridge abutment. One of the passengers in the boat was thrown from the boat and killed in the accident. The others that were in the boat, there were 3 couples, 6 people, young people in the boat, and the others were injured as well in the crash. The family of the girl who died sued the Murdaughs for wrongful death, and in the process of that, Alec Murdaugh was required to produce his financial information. And what came to light was that he had been stealing from his clients millions of dollars, stealing from his personal injury clients for years. And that then exploded into what the prosecutors claim is the murder of, is Alec Murdaugh murdering his wife, Maggie, and son, Paul. So this case has been going on for quite a long time. And the prosecution's theory of the case is that it was the financial pressure that led Alec Murdaugh to murder his wife and son, hoping that the sympathy that he would get would postpone his law firm looking into all of the misappropriation of funds and give him time to find a way to pay that money back. That is part of their theory of the case. Of course, the defense absolutely does not want any of that information of all of his prior bad acts, because he has been charged with roughly 90 financial crimes that are still pending. And so the defense doesn't want that to come in because you always risk the jury jumping to the conclusion that because he's a bad guy financially, he's a bad enough guy to murder his family. Now, the prosecution's position is that it's not being offered as character evidence for him. It's being offered to prove motive, which is a valid reason to bring that kind of evidence in. So it's an interesting legal argument. It does kind of get into, how many angels are on the head of a pin, but it's an interesting legal argument. And the prosecution brought it to the judge and said, Judge, we want a ruling before court starts, because this could be a very prejudicial issue. We want the court to make a ruling before we get started that information can come in. Now, the defense did not file a motion in limine wanting to keep it out. They said, we'll deal with it if it comes up at trial. And so the judge agreed that, in fact, a motion in limine cannot be for the purpose of trying to get evidence in, only excluding evidence. So that was kind of an interesting finding. It will be very interesting as we go along for the judge to see how the judge rules when it comes to that information coming in, and whether it will be allowed in, particularly since it's walking this fine line of, does it speak to his character and his propensity to commit a crime, or does it speak to the motive of the crime? There are 255 people on the potential witness list. So it will be very interesting to see how many of those witnesses are actually called. So today we heard opening statements. We heard the prosecutor say, and one of the things that has been most interesting is that early on, Alec Murdaugh denied that he was there at the family hunting property before the murders. He claimed that he came there after he found them. They were already dead, and he stumbled on this gruesome scene. But when the prosecution got a hold of the cell phone records told a vastly different story. There was a Snapchat video that Paul posted 3 minutes before his phone went silent. And in that Snapchat, you can hear Alec in the background talking. He and Maggie are talking about the health of a friend's dog that's there on the property, and whether or not one of the dogs killed a chicken. And and Alec can be heard in the background. So that's pretty damning evidence. There's evidence that after that, Alec then got in his car, drove to his mother's home on the pretense of checking in on his mother, potentially to create an alibi for himself, and that and that he came back and then called 911 and reported the bodies. Interestingly enough, I thought there was a very interesting definition that was given in opening statements by both lawyers. I'm assuming that it is part of the South Carolina jury instructions, but I thought it was interesting. They both quoted the definition for reasonable doubt as a doubt that would cause a reasonable person to hesitate to act. So I thought that was, for those who are always trying to figure out what reasonable doubt really means, I thought that was a good definition, and I would pass that on. The prosecutor pointed out that the credibility of witnesses is purely a jury function, that the judge will decide how the trial goes along. We often say the judge calls strikes and balls, but it is entirely up to the jury to determine the credibility of each witness. And you can believe them all, you can believe one, you can believe none. So I thought the prosecutor made a really interesting point, which I thought was very effective for the jury. And that's that he says, there's this video, and 3 minutes later, Paul's phone locks and never gets used again. Just a few minutes later, Maggie's phone gets locked and never is used again. So both of those things it was very effective the way that he presented it. Dick Harpootlian, who is the defense attorney, the lead defense attorney, his name just gets me every time. Dick Harpootlian took an interesting tactic in his opening statement. He went right to the graphic details of the murder. He went right to the really graphic discussions about the murders, the conditions of the bodies, the trajectory of shots. I mean, he really went in hard on that. I think it was designed to allow Alec to look human, because he then started to cry and, dabbed his eyes. And so I think it was designed to do that. I also think that his point was, this man sitting here could not have done this awful thing to his own family. He could not have done that damage to his own wife and child, that it was so heinous and gruesome. I'm not going to get deeply into the description because I don't want YouTube to demonetize us or accuse us of being too gratuitous about things, which is why you see YouTube creators using words like unalived and those sorts of things, because we're trying to skirt the YouTube rules. So, but I do, if you are all interested, you can listen to that. It is on Law and Crime's YouTube channel from today, and it is late in the day. It started at about 3 o'clock, so it was the after lunch time. So if you wanted to catch the last half of their live broadcast of the trial, you can see that. It was, I'm sure it was very hard to listen to for the jury and the witnesses. We did notice that Alec's family were there, his siblings and his surviving son were there to support him. Several of them are on the witness list, so I don't know that we're going to see much more of them, because I suspect that they will be excluded from the courtroom until they testify. Usually that's the case because they don't want people listening to other people's testimony. So we have about 276 folks in following and watching tonight. So thank you for all of you. I know that you have many things you could be doing with your Wednesday evening, and so I appreciate that you're with us. If you're new to the channel and haven't subscribed, please do that. Subscribe and ask for notifications. As you all know, I am going to be in the courtroom at the Lori Vallow and Chad Daybell hearing starting April 3rd here in Boise, Idaho. And although we're right now doing twice weekly scheduled times that we're going live, that's going to change once the trial starts. You're going to be looking for more YouTube shorts where I'm just getting on really quick to give you a quick update about what's going on in court, what witnesses are going to be testifying, what's been happening. And then you're going to want to get notifications for those, as well as lives that happen when interesting things occur during the trial. If it's a particularly interesting trial day, I certainly will be getting on after court is over to go through what's happening with the witnesses. And that is going to be doubly important if the judge continues the ban on cameras. At this point, the judge has banned all of any cameras and any live streaming going on in the court from the courtroom. I know that the families of the victims have issued a plea. I know there's a petition out there being circulated, and I know that Kay and Larry Woodcock issued a plea. In fact, just today it was on East Idaho News with Nate Eaton, begging the judge to reconsider. So we don't know what's going to happen, whether the judge is going to reconsider that. But if there are no cameras in the courtroom, you are definitely going to want to be subscribed, because we're going to be in the courtroom and going to be there to give you the breaking and on the spot information about what's going on in the trial. So please subscribe, please hit notifications, and please hit the like button today, because it really does help with the algorithm as we go forward. The other thing I wanted to mention before we pop over and talk about the Kohberger case is these quilts. This one, the colorful one behind me, is a quilt that I just, the top is finished. It's not finished being quilted yet, that I made for my daughter. She asked me for it for Christmas. It's a little bit late. And then this guy over here is our first square in our True Crime Quilt Guild Quilt Along program. So we have 2 videos up already. The next one's coming tomorrow, talking about how to create this block, which is the center block for our quilt design. If you're interested, the links to the pattern will be in the show notes, and you can join us at some point. We're going to do a live where we're going to do a show and tell of how it all turned out and what everybody's been working on. One of our really generous followers has offered to professionally quilt this one once it's done. And then I think we will probably raffle it off so that we can donate the proceeds to probably to the Center for Missing and Exploited Children. So that's the excitement going on with quilting. Please, if you're interested, drop me an email or check out our show notes and quilt along with us. So let's talk about Bryan Kohberger. We're just at about the half-hour mark. We don't have a lot to talk about with Kohberger, but we do have a couple things that we need to talk about, and then we'll take some questions. I like to set the second half of the show aside for your questions. Please, while you're writing your questions in the chat, start them with the word question. It makes it easier for our mods to find them when they're sorting through, because our chat moves pretty quickly. So let's talk a little bit about Kohberger. At this point, you probably have heard that at some point, Ann Taylor, who is the public defender attorney who was appointed to represent Bryan Kohberger, previously represented 2 of the mother and the stepmother of 2 of the victims. At the time that Kohberger was arrested and Taylor was appointed, she was currently representing Kara. She is Xana Kernodle's mother, and I think she goes by a different last name. Her name is Kara. In her criminal history in the court records, she is listed as Kernodle, but she may go by a different name. She has had a long history since the mid-90s of drug and alcohol issues, DUIs, drug possession problems, which makes Xana being at college and being successful and doing so well at college even more remarkable. But her mother, Kara, has had quite a long history of drug and alcohol criminal charges. At the time that Ann Taylor was appointed to represent Bryan Kohberger. She was currently representing Kara Kernodle, Xana Kernodle's mother, in some pending drug charges. Now, I worked for the public defender, and I know how this works. It works that you happen to be on for the day that arraignments, or you pick up cases, and you get appointed to represent a client. Sometimes you get appointed more than once to represent that client if you've previously represented them. And then a big case comes along, and the state Office of Public Defense Services comes and says, we need a particularly qualified lawyer to represent this big case. In that judicial district, Ann Taylor is the only death penalty certified to be lead counsel lawyer. She's the only lawyer in that jurisdiction that is certified and is qualified to be lead counsel. So I'm pretty sure that what happened was the state came down and said, we want you to take this case because you're certified and qualified to do that. And so you need to clear the decks. And that includes withdrawing from any potentially cases of conflict. Now, I have gone back through, and there's a newsletter out that I've written documenting how I thought through all of this. I've been through the rules of professional responsibility for Idaho, and I've done the analysis that lawyers do when they're faced with a question of whether or not there's a conflict of interest. And my reading of the rules of professional responsibility is that it is not a conflict of interest. Now, does it feel weird? Yeah, it does. It feels kind of wrong. But in the black and white rules of professional responsibility, it is not a conflict. Here's why. Kara Kernodle is being represented in a case having to do with drug possession. It has nothing to do with her daughter Xana, with her daughter Xana's death, or with anybody associated with that. So that means that she's not privy, and Taylor is not privy to information about a victim that could possibly be adverse to her client, Bryan Kohberger. Now, there's a bunch of speculation out there, and there's a bunch of people who've got all these conspiracy theories backed up. Yes, Bryan Kohberger at one point had drug addiction issues. We do not know whether he was a current drug user or not. We know that at some point in his teens, he was addicted to heroin. People have made that jump to, he must have been going to that house to get drugs from Xana and her mother. There is absolutely no indication that Xana Kernodle was involved with drugs, that she was involved with her mother's problems, or that she was that any of them had in any way been acquainted with Bryan Kohberger. But people are jumping to that conclusion, to that speculation, which is raw, absolutely ridiculous in my mind, sort of conspiracy, and then saying if that were the case, Ann Taylor would have a conflict. So you can't decide conflict on speculation. You have to decide conflict on facts. And what we know right now is that there is nothing that links Bryan Kohberger and Kara Kernodle and Xana Kernodle other than a random act of brutal murder. And because of that, there is no conflict. Likewise, it appears that at some point several years ago, that Madison Mogen's stepmother was represented by Ann Taylor. So her stepmother is a past client. Now, there is even less duty to a past client because it's less likely that you're going to come across two people who are going to be adverse to one another with a past client whose case is long done and settled. So what has happened is there is a court database. There is a statewide database. And every lawyer, when a lawyer is assigned to a case, it shows up in that database. And you can do a search by the lawyer's name and find every case that lawyer was ever assigned to, including those cases which are listed as inactive because they've been resolved. They're cases that are done. So she shows up still, maybe as the attorney of record for this stepmother, although she probably has had no contact with this person in years. So people have jumped to the conclusion somehow that because this is a small jurisdiction and that often this happens, it often happens where one person, where related people may be represented by the same lawyer, because it's a small town. So I don't think anyone should read too much into this, is my first caution. And my second caution is everything that we know right now, with the facts as we know them right now, says that Ann Taylor does not have a conflict of interest under the rules of professional responsibility. Now, I can't say it doesn't feel weird, but we don't decide those things on what feels weird, and we don't decide them on what might develop. We decide them based on the facts as we know them, and we apply the rules of professional responsibility the same way as we would apply any other law. So if you want a more in-depth analysis, it's in my newsletter. You can find it at thelorivallostory.com in the archive. And you can look through that analysis. I'm certainly not the only lawyer who has said they don't believe there's a conflict. But like every ethical question, there are going to be people on both sides. So there are also lawyers out there who are saying, oh, this is a definite conflict and she should withdraw. I don't agree. Reasonable minds can differ. And so that's what makes the world go round. So let's take some questions from you all. T Diva, yes. If Paul had not crashed the boat, none of this would have been known. This is in the Murdaugh case. So I think this is true to a certain extent. We know that Alec Murdaugh had been playing this shell game with money and moving money around and sort of robbing Peter to pay Paul and really what had gotten in horribly deep into this. We know that he'd been stealing from clients. We know that he'd been stealing from his own law firm. Whether or not that would have ever caught up with him, it's hard to say. But if Paul had not crashed the boat, if Paul had not been drunk at least 3 times the legal limit, he was tested in the hospital an hour or 2 after the crash and still tested at 3 times the legal limit, which means he very likely was more intoxicated at the time of the accident. if he had not run that boat into the bridge abutment, it is hard to say whether his family's financial shenanigans would have ever come to light. It's possible that Alec could have continued to move the pieces around and kept it a secret. But as best anyone can tell, he stole somewhere between $8 and $10 million over a period of time, often from very vulnerable clients who were poor, clients who were disabled due to accidents, clients who had been injured or lost family in horrible accidents, and he stole from them. And this is a guy who had 3 homes and who bought expensive champagne for everybody in the room. I mean, he was a country club lawyer, and he was 4th generation solicitor general, which is the chief law enforcement officer in the county. Hi, Jenny Meow Meow. I have a cat meowing outside my door. Question: what do you think the strategies were for both the prosecution and defense for not objecting to the trial being held in Alec Murdaugh's home area? That's a really good question. Knowing that this family for 4 generations has been so well connected, and knowing what we know about the fact that many people will say you never want to cross a Murdaugh and you never want to get in debt to them, because if you do, they own you. You never want to owe them a favor, or because then you're in debt to them forever. So it is kind of hard to understand why neither group, although I could understand why the defense would want to keep it there, because he's one of those guys that people look up to, that the average person in town is going to say, you know, this is somebody who is incredibly connected, who can be very generous, and at the same time is somebody you don't want to cross, almost like a mob boss. It's that same sort of family, very tight-knit, don't want to cross them kind of mentality. So it is hard to understand, though, why the prosecution wanted to agree to keep the case in Colleton County, because it was interesting when I was watching Gigi from Pretty Lies and Alibis. She was there for jury selection and was saying there were many people. They subpoenaed 900 people to get enough people for this jury, and there were many people who said, oh yeah, he's my cousin, she's married to my cousin, that he's my uncle's daughter's wife, you know, he represented me one time. I mean, a number of people who said they had some sort of connection with Alec Murdaugh. So, and that makes it complicated to get a jury to find a jury. And many people who, when they were asked, have you heard about the case? Yes. Have you formed an opinion? Yes. So, question: do you think they'll throw out the t-shirt evidence? This is interesting. Now, we haven't seen all the t-shirt evidence. We've seen a fair amount of it, because some of the report was attached to a motion that Dick Harpootlian filed to challenge the t-shirt. So for those who don't know what we're talking about, the night of the murders, Alec Murdaugh was wearing a white t-shirt, and the t-shirt was seized, and a blood spatter expert said that there was evidence of bodily fluids, the blowback from a gun. So when someone is shot, aerosolized particles of body fluids come toward the shooter. And so they said there was spray on the t-shirt that was consistent with bodily fluid spraying back for a gunshot. I'm trying to be YouTube friendly as I'm trying to talk about these things. So they did a series of tests on that t-shirt. They started out by using a substance that fluoresces blood spatter or human tissue spatter. And one of the problems with that was that it discolored the whole shirt and made it very difficult to have extra forensic experts examine and verify what the state lab had found. But when they sent the photographs of that shirt to a spatter expert, the spatter expert then agreed that there was some sort of spatter on the shirt. Now, we don't know what Alec Murdaugh did in that intervening time between the time that Paul's posted that last snapshot video and the time that Alec reported the murders, which was about 2 hours. So we don't know. We don't know if he cleaned up. We don't know any of those things. We don't know if he had something on over the top of that shirt. He was wearing shorts. It's impossible to say. We also know that at one point he picked up, it was hot, South Carolina, and he picked up the hem of his shirt and wiped the sweat off his face with it. So that caused problems with the analysis as well. I think the t-shirt the evidence and the report will be admitted. Dick Harpootlian has made a great deal of the fact that one of the first tests that was done, which is from my understanding, not overly sensitive test, said there was no human blood on that shirt. Later tests revealed there was human blood on the shirt. In fact, Maggie's DNA was on the shirt. So we don't know for certain because we haven't seen the experts yet. We haven't seen the testimony. I expect the judge is going to let that evidence in, and then he's going to let the defense attack the methods and the way that the shirt was handled to raise reasonable doubt. That would be a typical way to handle that piece of evidence rather than excluding it to allow it to come in and then allow the defense to attack the process. Question. Hi, Trisha the trucker. I wonder where you are tonight. I always am so glad to hear from you. And I'm always curious to find out where you're laying your head tonight. Question. In a family that has this much power, do you think they planted someone in the jury? I think it's possible. I think it's always possible. So the process is that the court issues summons to however many people they're going to bring in for a jury. We're going to see this same process happen in the Vallow case. They issue summons and people come in and then they report for jury duty. And the initial discussion is usually if there are things that would sort of automatically disqualify someone from serving, either they're hard of hearing or they're ill or a number of other reasons that they wouldn't be available or appropriate for jury service. So they weed all those people out first. Then they start going over jury questionnaires and trying to figure out whether or not they can find people who can be open minded and can say, yes, I may have heard about the case, but I agree that I am going to apply the law to the facts I hear in the trial and make a decision about what's true and what's not based on what I hear in court. So that's kind of the way it works. It's a little hard to plant somebody on a jury unless you have somebody on the inside who can issue that jury summons to begin with, and then having somebody on the inside who can assist with getting that person through the voir dire process. Because ultimately what's going to happen is the lawyers are going and the judge are going to question these folks about their ability to sit on the case. And then the judge is going to be allowed, the judge is going to dismiss people who he believes can't be fair. And the juries are the attorneys are going to get the opportunity to challenge jurors who they don't believe are good for their case. So it's a complicated enough process with enough moving parts and people involved that I think it would be difficult to plant someone. Now, I'm not saying it's not possible, because these are very powerful people who know know a lot of people in a lot of powerful positions. So it's possible, but it would take a real concerted effort to make that happen. Good question, though. Cheryl McKay, were the family staying at the hunting lodge at the time of the slayings? If not, it makes you wonder how or why they were lured there. Well, according to what we have heard so far, there will be evidence presented that Maggie was in fact lured there by Alec. And a lot of people have speculated that Paul just happened to be there. He was there checking on a friend's dog. I think this was a family that kind of came in and out of there. We heard early in the opening statement that this hunting property was not Maggie's favorite place. They had a beach home, and that was her favorite place to be. And she didn't really go to the property unless there was a reason. But that wasn't the case for Paul. It was a popular place for he and Buster, the other brother. They were there frequently. They went there shooting. They went hunting. So I think there's been speculation that Alec asked Maggie to go to Moselle that night, and that perhaps Paul was just accidentally there. L.C. Collins, do you think it's possible Alec's law firm was really blind to his theft for all these years? Yeah, I think it's possible. I think it's possible because they weren't looking, because it never even crossed their mind that he could be doing something like that. And I think he was pretty sly about it. One of the things that he was doing, which is it takes a little bit of explanation about civil cases. So often when a big personal injury case is settled, and let's just say, well, in the case of Gloria Satterfield, who was Alec's housekeeper, who supposedly tripped over a dog and fell down the stairs at Moselle and hit her head and died 3 weeks later. And Alec said to her sons, "You need to sue me so my homeowners insurance will pay." And then he negotiated a resolution that included a settlement of about $4 million. He told the sons he had settled the case for somewhere around 500,000, none of which they saw. So often what happens when you have a settlement in a big personal injury case where there's a large sum of money, it's the court requires, the state requires, the insurance companies require that money goes into a trust, and that it's not just handed to the person in a lump sum. And so there is an organization in Colleton County that handles, there is a corporation that handles these trust accounts, and it is called Forge Incorporated, I think. I can't remember, but it's called Forge. And so Alec went down to his local bank, and there's a lot of litigation going on, a lot of criminal charges going on about Palmetto State Bank and his good friend who ran the bank. He went down to the bank where his good friend ran the bank and opened a business account that he named Forge. And so every time a check would come in written to Forge that was supposed to go into a trust for a client, he would deposit it in his Forge account. And so it wasn't necessarily something that his firm would have caught. There were irregularities in the collection of fees, and he kind of moved those pieces around. He would say, "Oh, well, I had to pay a portion of the fee to this other person," and then he would borrow money and replace it before they got wise. So it really wasn't until there were a lot of questions about his financial dealings that his own firm started thinking, maybe we ought to look a little deeper into his dealings with the firm. We are just about out of time. Really have time for one more question. I see there's a couple here. We got Trish's already. I see Lee here, and I'm going to, oh, there. How can they throw out the t-shirt now that the defense has mentioned it in his opening statement? Good question. I don't think they're going to. I think, and I do remember that he mentioned that. I think that he did that as a sort of a preemptive strike, to say, hey, listen, jury, remember you're going to hear about this t-shirt, and you remember that you're going to hear about how poorly it was handled, because I think he believes that the judge is not going to keep it out. And I don't think there's any basis really for the judge to say, no, I'm going to exclude it. So I think it's going to come in, and I think he was trying to sort of inoculate the jury about what they were going to hear about that shirt. So I want to thank everybody for being here tonight. Hopefully I didn't overwhelm you with too much information, but I always enjoy our chats, and I always enjoy your questions and how insightful they are. And so I look forward to getting back together with you on Friday. On Friday, we'll be talking primarily about the Valor Daybell case, any developments in that first, and then we probably will move on to other subjects, because there's not a lot going on in the Valor Daybell case right now. A little quiet right now. Everybody's got their heads down getting ready for trial. I'm sure that John Pryor is working his little buns off right now because there's a lot to do between now and the time trial starts. And he's probably not as far ahead as Lori's attorneys are because they've got a bigger team. So I look forward to seeing you all on Friday, 6 Pacific, for another version, another night of TGIF. Bring your favorite beverage and let's get together on Friday. Good night, y'all.